was a case involving generic quote-unquote production of medicine in Thailand. Again, the case was brought up to the IP court. It was also addressed to the Competition Bureau. Now, the Competition Bureau, just for information, is a department in the Ministry of Trade and Commerce. And I think here, perhaps, some of the features of which are necessary for a competition authority to work effectively and enforce the law, and there is agreement on this, there is independence. Functional independence in its ability to assess the case, to take decisions, and for due process and appeal through the courts. Now, clearly, if the agency is not an autonomous and is not an independent agency, and it's part of the government agency, the competition law and the competition policy become blurred, and the question of whether there is effective enforcement or not is something that go beyond this discussion here, but it is more of what the government attitude toward IP and the rest. Now, more specifically, if we look at the ability of the competition agencies in many developing countries, which have the capacity and have been able to address the question, there are a number of technical issues which they face themselves. That is, their ability to address these questions. And let me just mention some of them. So I think if you talk to case handlers, most of them will address that there is problems about developing criteria, methodology, which are used in the various different analysis, which are and remedies which can be applied to infringements, including, for example, network industries, and for example, areas where it might be abuse, allegation of abuse of dominance. The lack of this economic analysis, the stand and assess IP competition cases, I think something that need to be strengthened in these young competition authorities. The area which I think also there is need for importance is the ability of the competition agency to use its power to advocate for IP on these issues in order to ensure that IP are addressed in different forums other than the competition authority. Because IP requires innovation, and innovation can only develop if there are effective markets. If there are no competitive markets, clearly this will not take place. Last but not least, I think we talked about the TRIP agreement. And I think the TRIP agreement, as you mentioned, provide a large number of provisions for countries to enforce their legislation against anti-competitive practices. But those are on the books. The ability to enforce them clearly require cross-border and international cooperation in these areas. And without specific cooperation in this area, clearly there is very little to need. So I think this is one area perhaps where there is need for cross-border cooperation in order to ensure that the link between IP and competition policy is effectively enforced. Thank you.
Thank you. Thank you, Hassan. Time is always a very scarce commodity, and there isn't much time left. And therefore, I would directly go to the audience and ask whether there are questions. I think it's most important that you get the chance to ask questions. I can't see properly, but of course, the first row, there is a question. Please speak up.
Nicholas Thum, Chief Economist of the EPO. It's more a direct comment to Mr. Kramler from the European Commission. I very much agree with what you said in general, the analysis, and also specifically on the pharma inquiry that you've made. So very much. Just the very last point. I'm a little bit concerned about the message you have mentioned that actually with standardization organizations, it would be good that this issue, the IP issues, would be foremost dealt with by standardization organizations. I have some concerns there. It's exactly about what was mentioned by our last speaker, that I think that there's somehow a lack of competence, maybe with this on the side of standardization organizations. I also have the feeling from my experience that standardization organizations are actually a closed shop. I mean, it's mainly the people, the companies themselves that set up these standards. and of course they have a per se an interest, of course in strong rights. So I think it does not, maybe not even necessarily need a Rambus case, the case you have dealt with, but the constellation per se of a standardization organization that gives a standard which is a dominant position in the market already, and combining that with rights, I mean with IP rights, strong IP rights, that this might be a problematic case in itself, not necessarily only with an ambush case. So I think there is a problem.
Maybe Thomas, would you like to answer?
Very quickly, obviously we see this problem. The point I wanted to make is that ex post enforcement by a competition agency might not always be the right way to deal with these issues, because as we have seen in the Rambus case, it takes ages and the outcome is uncertain. I certainly agree with you that there has to be something has to be done with regard to standardization organizations, and as you know, we recently adopted guidelines on horizontal cooperation agreement that have a vast chapter on what minimal requirements we would like to see in a standardization agreement in order for us to be certain that there shouldn't be any problem with competition law, and that's participation, clear-cut rules on what happens with front commitments and things like that. That we are quite certain that there needs to be some minimum requirements in order for standardization organizations to function, and that's what we've incorporated in the guidelines.
Thank you. I think there was another question. Am I right? Yes, here. Please.
Maybe rather it's a comment, an observation. My name is Ermias Berglin. I'm a legal expert at UNCTAD, but from the IP angle. It's right that there could be some different outlook towards the issue from people who are specializing on competition with that those who specialize on IP. But the first thing I want to say is that it was very important for the Congress to introduce the issue of competition to this year's debate. I think it was not that much reflected in the past debate. Now, the issue is very much important for practical aspects, especially for developing countries. I'm saying this because in UNCTAD we also have a separate work program on IP and development, and most of the technical assistance requests recently we are receiving is much more targeted on legislative matters. I think it was touched upon during the presentation on the European experience, where competition law is actually a last resort mechanism, but much of the issues could be addressed at the early stage. And maybe just to outline in this area, some of the key technical assistance requests we have been receiving relates to the elaboration of national IP policy strategy and the relationship between patent and the local production of pharmaceutical products. I think with that, maybe I would like to maybe remind that there was a European Patent Office report which was called Scenarios for the Future, and in which it was highlighted that the patent trend is actually becoming the main problem for innovation and technology development than it was anticipated earlier. So maybe this is one area that we have to look at, that the design of the law itself is the most important area in addressing competition issues in intellectual property right. Thank you.
Thank you very much. 5 minutes left. That's the message. Any other question? Maybe a last question?